Until the adoption of the Copyright Modernization Act, photographers were not on an equal footing with other creators. Under the previous Copyright Act, photographers were not considered artists. They were regarded as technicians. When a customer ordered a photo from a photographer, the copyrights belonged to the customer by default.
Before the Act, it was necessary to obtain a signed agreement with the customer if the photographer wanted to own the rights to the work they produced. This is why Capic was created.
The Copyright Modernization Act has rectified this situation. As of November 2012, photographers are the first copyright owners of the work they produce. Regardless of whether the work is a work of art, personal work, or the result of a commercial order, the photographer automatically owns the copyright and the moral rights.
This applies to all new photographs taken after the Act was proclaimed in force and not to photographs taken previously. However, the Copyright Modernization Act does allow some people and institutions to use copyright-protected photographs without the photographer's authorization.
Capic still recommends drafting a contract that addresses the following issues: use of images, licenses granted, terms of payment, etc. It will always be worthwhile to specify in the contract as a point of information that the photographer is the first copyright owner of the image produced.
It's important to remember that a quotation or an invoice is not a contract, even though it sometimes includes certain contractual elements. A contract always requires the signature of both parties.
In the case of a private order for a photograph or image made by an individual for non-commercial purposes, the person who makes the order has the right to reproduce the photo as he sees fit, without the photographer's authorization. This person has the right to authorize anyone to do the same. They may print as many copies as they wish, distribute them, or publish them on the internet without limit. We are not talking about an organization or a corporation. We're talking about personal portraits, artist portraits, wedding photos, family photos, and any photos not used in a promotional or commercial content. However, any commercial use is prohibited without the photographer's consent. The customer may give the photo to another individual, such as their family, but may not sell it or give it to an organization or business for use in communications, because this constitutes commercial use related to marketing and public relations. For example, they could use it on LinkedIn, but not on their company's website. Obviously, this clause creates a problem for photographers who offer their services to individuals like wedding photographers or family portrait photographers. In order to override the Act's default position, customers should sign a contract containing the following clause: no reproduction is permitted without the photographer's written authorization.
Until last spring, educational institutions were required to pay royalties for each use of a copyright-protected work. Agencies mandated by authors and publishers, such as Access Copyright or Capic, redistributed the funds collected to the creators. For the time being, they no longer have to do this. The Copyright Modernization Act appears to authorize the use of any work in an educational context, free of charge and without prior permission, even if these works are protected by copyright. In addition, this educational exemption may extend beyond the walls of schools, colleges, and universities. Its definition is broad and somewhat vague. Photographers who want to prevent schools and teachers from using their images free of charge have no other choice than to protect them with a digital lock, such as a file access code and a password. The Copyright Amendment Act makes it illegal to bypass these protective locks. Since this prohibition prevails over the exemption, Canadian educational systems must comply with it. Obviously, these locks do not protect the print version of works, only the digital version. Moreover, an image purchased and then published online by a third party, such as a magazine, may be used with impunity by an educational institution, even if the author's website is locked. Therefore, at this time, there's no perfect solution for photographers. According to Capic, the inclusion of education in fair dealing does not mean that educational institutions can reproduce anything without prior permission. This exception is subject to very specific criteria and will involve case-by-case assessment. It is likely that the courts will have to decide.
Bill C-11 allows anyone to use a published work to create new work, such as a remix or mashup, and to publish it on condition that this is done solely for non-commercial purposes, and in principle, that the source of the original work is credited. Photographers who want to prevent their images from ending up in hundreds of dubious mashups or in the latest viral video without deriving any benefits must protect their works with a digital lock. A digital lock is a technical measure that limits access to the works contained on a website or on digital media. The owner of the website or the media may require, for example, that the user enter an access code or an ID password combination. Otherwise, the user may have to click an accept button after the description of the terms and conditions of use, just like the acknowledgement given when buying software on a DVD or by download. The Copyright Act makes it illegal to bypass this protection. This is the only way to prevent anyone from doing whatever they want with photographers' works. However, this solution results in several problems. Notably, it hurts marketing because it prevents search engines like Google from identifying and indexing the content of a protected site. An unindexed site does not appear in the search results. Once again, there is no perfect solution.